Jefferson County Court, law number 2 is now in session. The court is in session with two dockets, motion to revoke probation docket and the announcement docket on today's date of June 26th of 2024. Now, good morning, ladies and gentlemen. When we call your name, we're going to ask that you come up before the bench with your attorney. If your attorney is not here, then we will not call your name. Your attorney may be in another court. For example, probably in a district court handling another matter. And so district court has priorities over county court. And so we'd have to wait for your attorney to arrive. First case is cause number M332578, case is style of state of Texas versus Kimberly Ann Cox. That's Mr. Boudreaux's case. Kimberly Ann Cox is scheduled to be in court. Kimberly Ann Cox, see her here. Now, Kimberly Ann Cox was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. the court's bailiff called the name of Kimberly Ann Cox at the courthouse door. Kimber Cox did not answer. She is not in court presently. The time now is 9:27 a.m. on today's date of June 26, 2024. Ms. Bailiff, would you please call the name of Kimber Cox at the courthouse door? Kimber Cox. Kimber Cox. Kimber Cox's name was just called again at the courthouse door. Kimber Cox did not answer. Kimber Cox's attorney is here. However, Kimber Cox is not present. A reasonable time has passed to give Ms. Cox an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
Statements for bond forfeiture.
That motion will be granted. Kimber Cox's bond will be forfeited and a warrant shall be issued for her arrest in clause number M332578. And Mr. Boudreaux, this is your only case. You're free to go and you have a blessed day.
Thank you, Judge.
You're welcome. Okay. Dismissed. Next two cases are cause numbers 23 CCCR 1330 and cause number 23 CCCR 2233. Both cases are style of state of Texas versus Jorge Lopez. Mr. Lopez, would you please come forward?
He speaks a little bit of English, Judge. I think we might be able to get through.
Okay, now he pronounced his name Jorge?
Jorge.
Jorge. Mr. Lopez has two cases. Mr. Lopez, how are you doing? You doing good? That's good. Mr. Lopez, you're represented in your cases by your attorney. Attorney Charles Rojas, Attorney Rojas, how are you doing?
Doing well.
That's good. State is represented in these cases by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge, yourself.
I'm doing fine. Thanks for asking. Mr. Lopez, I have before me two cases. And they are cause numbers 23 CCCR 1330 and cause number 23 CCCR 2233. And in both of these cases, the state has filed motions to dismiss in each case. Is that correct, state?
That's correct, Your Honor. The field ID is a dismissal based on the plea on the felony, and the UCW is a dismissal for forfeiture.
Okay. Mr. Lopez, in cause number 23CCCR 1330, I have before me a motion to forfeit the weapon to the Beaumont Police Department. Mr. Lopez, well, first of all, Mr. Lopez, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Lopez, you may put your hand down. Mr. Lopez, I have before me a motion to forfeit the weapon, in this case, cause number 23CCCR 1330. Do you recognize this document? You have to speak up. And is this your signature on the line that's titled defendant? Mr. Lopez, before you signed this document, did your attorney go over this document with you? Did your attorney go over this document with you? And did you understand everything that your attorney went over?
Yes.
And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Lopez, you're asking the court to approve this motion to forfeit the weapon to the Beaumont Police Department? Okay, Mr. Lopez, the court is going to grant this motion to forfeit the weapon to the Beaumont Police Department and state you will be dismissing cause number 23CCCR 1330 for forfeiture of weapon in this case. Is that
That's
correct?
correct, Your Honor.
Okay, Mr. Lopez. I'm signing the dismissals in cause number 23CCCR 1330 and cause number 23CCCR 2233. Mr. Lopez, your attorney is going to get a copy of this dismissal, well, of these dismissals. Once he gets copies of these dismissals, he'll give them to you. You're free to go, and you have a blessed day. Please stand in front of the court coordinator, the end of the counter.
Thank you.
You're welcome, and you have a blessed day, Mr. Lopez, and you have a blessed day, Mr. Ross.
Thank you, Judge.
You're welcome.
Can you send me, Nicole Lavelle back?
You send it, okay, you need Newell. Go back, not even here, he left. We have any pleas ready? Miss Haley? Haley, she needs you. Okay. Next two cases are cause numbers 23 CCCR 1824, cause number 23 CCCR 1825. Both cases are style of state of Texas versus Drew Anthony Garner. Drew Anthony Garner. Mr. Garner, your full name is Drew Anthony Garner. How you doing, Mr. Garner? That's good, Mr. Garner. You're represented in your cases by your attorney, Attorney Mel Shalanda. Attorney Shalanda, how are you doing?
Okay, for Wednesday, Judge.
Okay. Mr. Shalanda, what is your announcement in Mr. Garner's cases?
Yeah, we're struggling with the videotape, from the DA's office. We got somebody working on it. It's not James, it's some female there that we can't seem to open it. I'm asking for at least one more resetting.
Okay. State, you have any objections?
No objection, Your Honor.
Okay, okay, we're gonna reset it, keep it on the announcement docket. What was that date again? In this case will be, well, these cases will be reset to July 31st, 2024. Mr. Garner, your attorney will be given copies of your reset. Once you get a copy of your reset from your attorney, you'll be free to go. You have a blessed day. And Mr. Mel Shalanda, once you get copies, you're free to go and you have a blessed day. Please stand in front of the court coordinator. You're welcome. Okay, on what case?
On Oscar Reyes.
On your announcement document, it's initial appearance.
Oscar Reyes, cause number 24 CCCR 2724.
Your Honor, I do have a translator, but I was speaking to the
Oh,
bailiff. And she said that we may need to use Cindy Jennifer. My client brought a gentleman who's quite competent to translate, but I'll leave
okay,
that.
yeah,
to the
we'll
court.
use our court translator, man, some legal terms. Yeah, he might speak Spanish, but there may be a legal term or two you might not understand. Let's, did we call Jennifer or just call Jennifer, send it, it'll be a few minutes. Next case is Eric Carbon, cause number 23 CCCR 1286. Eric Carbon,
He's across the street at drug court.
oh, he's a felony, okay.
Yes, Your Honor.
Okay, we'll wait for him to come. Next case, next two cases are clause number, actually, next three cases.
Your Honor, can we speak on? One Corbin? I'm just waiting to see what they're doing across the street. I
The
don't know.
felonies are the same incident as the misdemeanor.
I'm
Okay.
not sure if he's taking a plea or what he's doing across the street.
Okay,
I'll
Find out.
we'll find out.
Thank you.
Damon McMillan,
Same thing, Judge. He's
or
also-
DeJuan McMillan,
He's also.
he's across the street too? Okay,
You said he played already, so I'm gonna get him sent over.
They did.
Like you said, he, or you said he.
Oh, yeah, yeah. Yeah, so he.
okay, so they're gonna bring him over. Okay, we need to call. Charles Jason Kramer. Calls numbers 23 CCCR 1966, calls number 23 CCCR 1967, and calls number M333072. All three cases are style of state of Texas versus Charles Jason Kramer. Mr. Kramer, is that your full name?
Yes, sir.
How are you doing, Mr. Kramer?
All right, all right.
I'm doing fine, thanks for asking, Mr. Kramer. You representing your case, in your cases by your attorney, Attorney Ryan Matuska. Attorney Matuska, how are you doing?
Morning, Your Honor.
Good morning. State is represented in these cases by Attorney Haley Simmons. Attorney Simmons, how are you doing?
Great job, Doctor.
I'm doing fine. Mr. Matuska, what is your announcement?
What? I'm gonna hire another attorney.
I don't think you had this attorney, did you?
No, the state.
Okay, so, okay, because I think, now, let me tell you something, Mr. Kramer. You were pro se for several months, is that correct?
Yes, sir.
And then we came up, I think it was it set for trial?
Yes, Your Honor.
And on the trial date, you said you wanted a court-appointed attorney. All right, the court looked at the affidavit, approved the court-appointed attorney. And now, like I said, the case was on the trial docket, which means it was set for trial. We're not gonna prolong this case with you seemingly playing games. All right? So, Mr. Matuska is still on the, he's still your attorney. I'm gonna set this case for trial. Okay, if you have an attorney, you hire an attorney, your attorney better be ready for trial.
Sure.
All right?
Your Honor, I have all the discovery, and if he does hire an attorney, I can provide it to.
Okay. Okay, let's set this on the trial docket. Okay, this case is set for August 5th for trial. In this case is, we're gonna give it a number 1 setting.
Is yours slow?
Yes, okay.
May we approach you?
Oh, great.
Mr. Reyes, could you come forward? You please, guys.
No.
Mr. Reyes is very nice.
Okay, this is cause number 24CCCR 0724, case of style of state of Texas versus Oscar Reyes. Mr. Reyes, speaks Spanish. He might speak some English. And we have, our, interpreter. Would you please raise your right hand? Do you swear to interpret Spanish to English and English to Spanish to help you God?
Yes, Judge.
Okay, you may put your hand down. Now, this case is set for an announcement. And Mr. Reyes is represented in this case by Attorney James Padgett. And Mr. Padgett, how are you doing?
Doing well. Good morning, Your Honor.
All right. Now, Mr. Padgett, what is your announcement? And now, this is your first appearance, I think you mentioned.
That's correct, Your Honor. The good news is we have received all the discovery on the case. Therefore, I really just need around 30 days or so to review the discovery with my client, and then I'll request an offer from the prosecutor.
Okay,
30 days, July 24.
okay,
That's
What-
correct. No problem.
Is that a good
We can
day?
do that. Absolutely.
okay, Mr. Raji, would you,
What day of the week?
hold on a minute.
It's gonna be on Wednesday.
Okay, perfect.
Okay, you can tell Mr. Reyes that his case is being reset to July 2024 at 9 AM. And he needs to be here in person.
Twenty-fourth of July,
Well,
correct, Judge?
if you could also tell Mr. Reyes that I will be sending my translator all the paperwork. They're very close. So I'll be sending him all the paperwork today.
También dice que le va a le toda la información de los papeles a la señora que va a hablar con usted. Okay?
Thank you very much.
Okay, okay, case is reset to July 24th, 2024. Okay, thanks a lot, Mr. Raji.
You're welcome.
Thank you very much.
All right, y'all have a blessed day.
Thank you.
Tenga buen día usted.
All right.
Over here.
Okay, have any paperwork. No, he's not here. We have somebody else named Nakisha Lynette Ivory.
Yes, we're here.
Wait, I gotta.
We've reached.
Oh, you have another, she have more than one case?
Yes, sir.
Okay, I was looking at the dismissal. She's working on the other paperwork.
Yeah, that's fine, because we have an agreement with the state, everything, so we're just.
Okay.
It's gonna be dismissed.
Okay.
Thank you.
Yeah.
Not sure why. He said, like I told you, it looks like it's $5. Not that he attached the wrong.
Yeah.
I just realized that the setting I was given, I'm gonna be at federal training.
Okay, is the guy here?
He just walked out the door.
Oh, okay. Well, give us give him another court date.
Okay.
So is he still in the building?
I can go check, find him.
Okay.
Was that July? I mean, August. Yeah, August 9th.
Okay, so Mr. Kramer, 3 cases will be set for trial. We set number 1 for trial on August the 19th, 2024.
Yeah.
And Mr. Matuska, you can give that date or that date to your clients, to your client. Mr. Minaldi.
The bailiff has told me that he hasn't been brought over. Requested
All over where?
anywhere.
They didn't bring him on
in
the,
county. He wasn't requested, so he's not.
He wasn't requested.
I will be here tomorrow for, and you have your jail run, if we could get him here tomorrow.
the Juan Mike Miller.
Yes, well, he was on the docket. I sent it to them and it had that he was in jail.
They said they didn't bring him over.
It's not on her list. On who list? The list that Sarge created. Well, I'm sorry, but I put it on the docket that he was in jail. No,
I believe you,
I just want justice.
Oh, okay.
but I will be here tomorrow, Judge.
It has yes on there that he's in jail, and that's all we do. So, I'm sorry. I did my.
Okay, so you want him set tomorrow on the
With
jail run?
I will.
Okay,
Because I'll be here tomorrow already, so we'll just.
Well, you know, I'm gonna text him, and let him know he's slipping. Yeah, don't be trying to get. Yeah.
Okay, so so what about your next client, Eric Carver?
I don't have an update from drug court just yet, Judge.
Okay.
I'm waiting to see what they're doing.
Okay. Okay,
Thank you.
you're welcome. Okay, and who else we have? You still had a paperwork. You did? Okay, you did? Next case is Lakeisha Lynette Ivory. Cause numbers M 329-576 and cause number M329578. It's Ivory, your full name, is that Yakisha? Yakisa Lynette Ivory?
Yes, sir, it is.
How you doing, Miss Ivory?
I'm doing well. How are you?
I'm doing fine, thanks for asking, Miss Ivory. Would you please raise your right hand? Miss Ivory, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Ivory, you may put your hand down. Ms. Ivory, you're represented in your cases by your attorney Mark Faggett. Attorney Faggett, how are you doing?
I'm good, Your Honor. Thank you for asking.
Mr. Faggett, do you waive a record in Ms. Ivory's cases?
We do.
Ms. Ivory, in clause number M329576, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Ms. Ivory, it alleges that you, Yakisa Lynette Ivory, on or about February 12th of 2021, while you were in Jefferson County, Texas, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Ms. Ivory, do you understand what you have been charged with?
I do.
To this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
And are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charge?
That is correct.
Ms. Ivory, I also have before me a document that is titled Misdemeanor Plea Admonishment. It's on my tablet. It is also labeled as State's Exhibit Number 1. Do you recognize this document?
I do.
On page 2 of this same document, there are a set of initials, YI, on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document?
I did.
On page 3 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
That is also correct.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled Defendant?
Yes, sir, it is.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir, I do.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
It is.
Ms. Ivory, before you sign and initial these documents that I just showed you, did your attorney, Mr. Faggett, go over these documents with you?
Yes, sir, he did.
And did you read and understand everything that Mr. Faggett went over?
Yes, sir, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Ivory, are you a citizen of the United States?
I am.
Any objections to States
None.
1? No objections. States Exhibit Number 1 will be admitted. Mr. Faggett, you've advised and counseled Ms. Ivory. Is there any evidence that she is currently mentally incompetent to stand trial?
None, Your Honor.
And Ms. Ivory, your attorney, Mr. Faggett, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
No, I'm just playing. Yes, sir.
Okay. Ms. Ivory, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea of no contest, the state's offering 1 year deferred, $750 fine, 100 hours community service, interlock DWI education plus court cost, and the state has agreed to dismiss the companion case cause M329578.
Okay. Yes. What is a court cost? Were you appointed in this case, Mr.
No, I
Baker?
was not. I was retained.
You was retained.
So the court will know I've been blessed to represent this young lady's family and for many years, since about 1986.
Okay.
Long time. I can't believe I'm that old. Yeah. They found a few trinkets on the boat, but that was it.
Yeah, I was about to say it's really good.
That was horrible. Yeah, one of his daughters was in town. There were some twins that were Sarah's and Enos's. One.
Okay.
Made.
Ms. Ivory,
Yes, sir.
the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $750. You'll be required to pay a DPS fine of $100. You'll be required to pay court costs of $377, probation fee of $60 a month, your analysis fee of $15 a month, and a reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education an initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is, the total amount that you will be required to pay each month is $195 a month. Will you be able to pay the $195 each month?
Yes, sir.
You'll also be required to perform $100 of community service, install an interlock device on any vehicle that you own or operate, attend and complete a DWI education class, have an alcohol assessment. You will also be required to adhere to the other standard terms and conditions of this probation. And the state will be dismissing cause number M329578. Ms. Ivory, do you understand do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Ms. Ivory, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Ivory, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Ms. Ivory, you're going to stand next to the court bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day.
You too, sir. Thank you. Have a blessed.
You are. Thank you. Yeah, okay.
You remember I approached on another case that you have on the docket tomorrow?
Hold on a minute.
It's the Beard case.
Okay, hold on a minute. Yeah. Yeah, she's supposed to be, she's being bench warranted back from,
Yeah, she's basically served her time, Judge.
well,
I mean,
she's been found incompetent. And you know as well as I know, the court cannot proceed with any, I mean, that's something you have to talk to the district attorney about.
yeah, we can do it. Another appointment pretty quick after 9 o'clock.
Okay. The court is in session and calls number M 333-112, case of style of state of Texas versus Jericho Gerard Thomas. Mr. Thomas, is that your full name? How you doing, Mr. Thomas? Doing all right?
Yes, sir.
That's good. Now, Mr. Thomas, you're represented in your case by your attorney, Attorney Ted Jones Jr. And Mr. Johns, how you doing?
Pretty good, Your Honor.
Mr. Johns, what is your announcement in Mr. Thomas's case?
I originally thought we were gonna be able to plead this case, because he has another case in drug courts that you've been working with us to carry on both of them at the same time. However, because the situation in drug court, I'm anticipating we have to go ahead and set this for a trial.
Okay.
Now, I'm due back in drug court on July the 8th. Okay, so it's not gonna be for a trial, it's gonna be for announcement. So,
Well, we'll just give it a different trial date.
well, I haven't
If
been able
that's
to
what
talk to this young lady yet in terms of a plea for it, and because someone else was on the case when she.
Now, let me ask you, what is he set for in drug court?
Announced.
What's that announced? Okay.
Yes, sir.
Yeah, this is an old case.
Well,
I don't think these cases, they rolled out of the same criminal episode.
I don't
yes.
believe- Do they?
They,
No, not this.
they're two different
No,
cases,
two-
so
No.
we could put them on different dates, yeah. Oh, this is yeah. Discharge of firearm.
To be honest with you, I think if after she looks at the case, I'm not
Let's
speaking
look
for
at
her.
it. We'll probably need to speak on it.
Yeah.
So you say you wanted to set it for trial?
Well, to be honest with you, I want to talk with her because I think when she looks at it, in my opinion, she probably would dismiss the case.
Okay, well, I mean, we can set it for trial. She said if she wants to dismiss the case when it comes up for trial, she can do it at if that's what she wants to do.
Yes.
If not, we just crank it up and go to trial.
Yes.
Yeah, so just set it, give us a trial setting. Okay,
Fifth. I think I've got something on that date.
August.
August 5th.
Yes,
Okay, this case was reset to August 5th of 2024 for trial. Mr. Thomas, your attorney's gonna get you reset. Once you get your reset from your attorney, you're free to go and you have a blessed day.
yes.
And you have a blessed day as well, Mr. Jones.
Thank you, Your Honor.
Okay. Okay, have Mr. Coleman, would you please come forward? This is cause number M 331-316, case of style of state of Texas versus Desmond Deshaun Coleman. Mr. Coleman, is that your full name?
Yes, sir.
Mr. Coleman, would you please raise your right hand? Mr. Coleman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Coleman, you may put your hand down. How are you doing, Mr. Coleman? I'm doing fine, thanks. Mr. Coleman, your case is set for what we call a motion to revoke probation. Oh. Oh, let me pull it up. And this is your first setting on this motion to revoke probation, is that correct?
Yes, sir.
Now, Mr. Coleman, I have before me a motion to revoke your probation that was filed by the Jefferson County District Attorney's Office. In this motion, it alleges that you, Desmond Deshaun Coleman, on June 21st of 2023, in County Court at Law Number 2 of Jefferson County, Texas, that you were found guilty for the offense of possession of a controlled substance, penalty group A less than or equal to 2 ounces. Your punishment was assessed at 45 days confinement in the Jefferson County Jail, a fine of $602. That doesn't seem right. Let me look at the judgment. Probably the fine of four. Let me see. That's fine plus court costs. Okay. Your general fine was $250. And plus court costs was $602. It's $250. So it says here found guilty of fine of 600 state. You have a trial member on this case. It says in your motion is, well, $602. Okay, well, I'll just read the motion. It says that, Mr. Coleman, that you were assessed a fine of $602 and the confinement was probated for a period of 1 year. In this motion, there are 3 allegations. First allegation alleges that you, Desmond Deshaun Coleman, failed to pay court assessed fees as ordered by the court, and as of January 8th of 2024, you were $540 in arrears in violation condition 9 of your probation order. Allegation number 2 alleges that you, Desmond Deshaun Coleman, failed to abstain from the use or possession of any drugs except those taken or possessed under doctor's orders as ordered by the court in that on or about October 24th, 2023, November 6th, 2023, December 1st, 2023, you provided a urine sample for a scientific analysis that showed the presence of metabolic byproducts, methamphetamines, cocaine, and THC in violation of condition 14 of your probation order. Allegation number 3 alleges that you, Desmond Deshaun Coleman, failed to perform the community service hours required as ordered by the court in violation of condition 17 of your probation order. Now, Mr. Coleman, if the court finds any one of these violations to be true, you can be sentenced up to 45 days to be served in the Jefferson County Jail. Do you understand?
Yes, sir.
Now, you should have before you a document that is titled Judge's Explanation of Rights of Defendants Without an Attorney. And I'm going to go over this document, which it states as follows. As a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Do you understand that option?
Yes, sir.
Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Do you understand that option?
Yes.
And number 3, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to an attorney, that is, give up your right to have an attorney to represent you, and you want to represent yourself, you may speak to one of the 2 prosecutors, the prosecutors or the assistant district attorney who are present in court. You'll have an opportunity to talk to them and see if you can work out a settlement on your case. Now, You may not speak to the prosecutor unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver is the second document that's before you that is titled Waiver of Counsel for Purposes of Guilty Plea or Proceeding Trial. I'm gonna go over that document with you in a few minutes. But getting back to this document, it says that be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you in your case, including a loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Do you understand that?
Yes, sir.
Now, at the bottom of that document, there are 5 lines. If your choice is to hire an attorney, then you'll place your initials on the first line to the left. If you've already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney, which means to give up your right to have an attorney to represent you, and you would like to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name below on the line that is titled Defendant, and you will date it today's date, June 26th of 2024. Do you understand?
Yes, sir.
Okay, do you have a pen?
Yes, sir.
Okay, you can make your choice.
Was that amendment right there, John?
Ms. Bailey?
Yes.
Oh, no, okay. May I see the document choice? Okay, now, Mr. Coleman, you've elected to waive your right to an attorney. You desire to represent yourself. Is that correct?
Yes.
And these are your initials on the line stating that you want to waive your right to an attorney and represent yourself. And this is your signature on the line that's titled Defendant, dated today's date, June 26, 2024. Okay. Now, you should have another document before you that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you see that document? That document states as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily meaning that you are doing it of your own free will. My waiver is voluntarily and knowingly. Knowingly mean that you know what you're doing or intelligently made. Okay, so it says that my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 26th day of June 2024 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed to me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed to represent me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled Defendant, and you will date it today's date, June 26, 2024. Okay, Mr. Coleman. I have before me the document is titled Waiver of Counsel for Purposes of Enter Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Coleman, before you sign and initial this document, did you read the document? Do you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Coleman, just have a seat and one of the prosecutors will talk to you about your case. Well, cracking. Well, we have a, Mr. Burbank. Okay, Nicole New,
Yes, sir. You're being mean.
won't you
Not true.
put this back down there?
It's just.
Okay, thank you.
Nothing.
Just confirm everything.
Tips County Court at Law Number 2 is back in session. Court is in session and cause number 23 CCCR 0882 case is filed in state of Texas versus Cole Newell. Ms. Newell, is that your full name? Ms. Newell, would you please raise your right hand? Ms. Newell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Newell, you may put your hand down. How are you doing, Ms. Newell? I'm doing fine. Thanks for asking. Yeah, Ms. Newell, you're represented in this case by your attorney, Attorney Tom Burbank. Attorney Burbank, how are you doing?
No.
Mr. Burbank, do you waive a record in Ms. Newell's case?
We do.
Ms. Newell, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Nicole Newell, on or about February 3rd of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Newell, do you understand what you have been charged with? And to this charge, Ms. Newell, how do you plead? Guilty, not guilty, no contest? Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Newell, I also have before me a document that is titled Misdemeanor Plea Admonishments. You recognize this document?
Yes.
On page 2 of the same document, there's a set of initials two sets of initials on a line next to a box that's checked no contendere, which means no contest. First set of initials is your attorney initials. The next set of initials in on your initials. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there is a signature above the line that is titled defendant. Is that your signature?
Yes, sir.
On page 3 of this, well, the next document that's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up the right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document that is titled Discovery Certification on paper. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant? Ms. Newell, before you sign and initial these documents, did your attorney go over these documents with you? And did you read and understand everything in these documents? And is everything in these documents true and correct
Yes.
to the best of your knowledge? Ms. Newell, are you a citizen of the United States?
They offer state one.
Any objections?
No objection, State.
No objection, states exhibit number 1 will be admitted. Mr. Burbank, you advise and counsel Ms. Newell. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Newell, your attorney, Mr. Burbank, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Newell, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waiver were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea of no contest, the state's offering 1 year deferred, $300 fine, 40 hours community service plus court costs.
What is our court cost? 277. And Mr. Burbank, were you appointed?
I was, Judge.
Okay.
But my husband.
Okay.
Ask the court to take judicial notice of her affidavit and
Okay. I'm gonna need a copy of my affidavit in English. Okay, Ms. Newell, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. Probation fee of $6 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll also be required to reimburse Jefferson County court-appointed attorney's fees of $250. Now, your total monthly installments is $158 a month. Will you be able to pay the $158 a month? No? Okay. Now, Ms. Newell, I have before me a document that is titled Jefferson County Affidavit of Indigence. I'm handing this document to your attorney, and he'll hand it to you. Ms. Newell, do you recognize that document? On page 2 of that document, it might be on the back page. Back of page 1, there's a signature above a line that is titled Defendant's Signature. Is that your signature? Ms. Newell, is everything on this document still true and correct to the best of your knowledge?
Yes.
Okay. Let me see. Let's see. Maybe 577. Okay. Now, Ms. Newell, the court is going to find that you're indigent based on the finding of indigency pursuant to Article 42.15 Texas Code of Criminal Procedure. The fine of $300 plus court costs will be converted to $46 in community service. And pursuant to Article 26.05 G-11, the attorney's fees in this case will be waived. The court will reduce your probation fee to the statutory minimum of $25 a month. So you will be required to pay a probation fee of $25 a month, a year nursery fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is, the total amount that you'll be required to pay each month is $45 a month. Will you be able to pay the $45? Yeah. Okay. Now, you will also be required to perform 40 hours of community service in addition to the 46 hours of community service that was converted from the finding court costs, which comes to a total of 86 hours of community service. Do you understand that? Okay. Now, Ms. Newell, you will also be required to adhere to the other standard terms and conditions of probation. Ms. Newell, do you understand the state's offer and the adjustments and findings that the court have made in your case? Yeah. And do you think that it's fair and just? And do you accept it? Yeah. Okay, Ms. Newell, I'll follow. People are in agreement with the findings and adjustments that the court have made in your case. Ms. Newell, just have a seat, and our court coordinator have to redo the paperwork. And once she finishes with redoing the paperwork, she's going to call you back up to a window, and then you'll follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go. And you have a blessed day, Mr. Burbank. I think this is your last case.
That is right.
Okay, you're free to go as well, and you have a blessed day.
May I approach?
Yes, okay. What case you here on?
I'm Galen Mass, MASS judge.
You say top of the 4th page. Oh, that's, oh, he has two. Okay, you say he's in jail?
Yes,
Okay,
I'm asking judge for a reset. I had just, I was having problems with my Odyssey, and they just explained to me that the video would be able to be viewed. We reset his felonies, other cases for 30 days for me to be able to look at.
let me, is he here? Did they bring him over? He's still across the street? Okay, so you need a reset for discovery?
Yes, sir.
You have any
No
objections?
objections, Judge.
Okay, cases be reset, and you're Ms. Long,
Yes, sir.
Tara Long?
Yes, sir.
Okay, nice to meet you, Ms. Long. You're welcome.
Thank you, judge. I appreciate it.
Okay, you're welcome. Yes.
Good day.
Judge.
Oh, that's the dismissal.
Yes.
Okay, is she here? Jose Enrique
Yes.
Valencia? That's the dismissal. Forfeiture. This is cause number 24 CCCR 0294, case of the state of Texas versus Jose Enrique Valencia. Mr. Valencia, is that your full name?
Yes, sir.
Mr. Valencia, would you please raise your right hand? Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You may put your hand down. How are you doing, Mr. Valencia?
Doing great. How about you, Judge?
I'm doing fine. Thanks for asking, Mr. Valencia. You're represented in your case by your attorney, Attorney Marcus Wilkerson. Attorney Wilkerson, how are you doing?
I'm doing well, Judge. Thank you for
Hey,
asking.
hey, Mr. Wilkerson, excuse me, you waive a record in Mr. Valencia's case?
Yes, sir.
Mr. Valencia, I have before me a document that is titled Motion to Forfeit. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Valencia, before you sign this document, did your attorney go over this document with you?
Yes, sir.
And did you read and understand everything in this document?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Mr. Valencia, you're asking the court to grant the motion to dismiss forfeit the weapon, in this case to the Nederland Police Department?
Sir.
All right, the court is going to grant your request. And state, I have before me a motion to dismiss the case, is that correct?
That's correct, based on that picture, Your Honor.
Okay. And Mr. Valencia, the court is going to sign the motion to dismiss the case as part of the plea bargain for forfeiture of the weapon. Your attorney will be given a copy of this motion to dismiss in a few minutes. Once you get a copy of this motion to dismiss from your attorney, you'll be free to go, and you have a blessed day.
Thank you, Judge.
Okay, you're welcome.
Thank you, Your Honor.
You're welcome. Is that McCracken? Jordan Hardy McCracken? Morning.
This is Mr. McCracken.
Mr. McCracken, your full name is Jordan Hardy McCracken. Mr. McCracken, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. McCracken, you may put your hand down. How are you doing, Mr. McCracken?
Doing well, how are you?
I'm doing fine. Thanks for asking. Mr. McCracken, I have before me, let's see, in cause number 23CCCR 0648, a document that was filed by the Jefferson County District Attorney's Office. This document is labeled, or titled rather, information sheet. In this information sheet, Mr. McCracken, it alleges, hold on a minute. Okay, in this information sheet, Mr. McCracken, it alleges that you, Jordan Hardy McCracken, on or about April 6, 2023, while you were operating a motor vehicle in a public place, Jefferson County, Texas, that, let's see, you committed the Class A misdemeanor offense of DWI second. However, state, are you abandoning enhancement paragraph?
That's correct, Your Honor.
Mr. McCracken, the state is abandoning enhancement paragraph, and what that means is instead of being charged with a DWI second, which is a Class A misdemeanor, you'll be charged with a reduced charge of Class B misdemeanor DWI first. Do you understand that?
Yes.
All right. Now, to this charge, driving while intoxicated first, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yeah.
And are you pleading guilty because you are guilty?
Yeah.
Mr. McCracken, I also have before me a document that is titled Misdemeanor Plea Admonishments. It is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials, JM, on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes.
On page 3 of this same document, there is a signature above the line that is titled defendant. Is this your signature?
Yeah.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yeah.
And is this your signature on the line that's titled Defendant?
Yeah.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have the right of appeal. You understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have before me a document that is titled Discovery Certification. I have this document on paper. And Mr. McCracken, do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? Mr. McCracken, before you signed and initial all of these documents that I just showed you, did your attorney, Mr. Hall, go over these documents with you? And did you read and understand everything that Mr. Hall went over? And is everything in these documents true and correct to the best of your knowledge? Mr. McCracken, are you a citizen of the United States?
State up for state one.
Any objections?
No objection.
No objection. States exhibit number 1 will be admitted. Mr. Hall, you've advised and counseled Mr. McCracken. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. McCracken, your attorney, Mr. Hall, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation?
Yes.
Mr. McCracken, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
For defendants plead guilty, the state is offered 180 days probated over 18 months with a $1,000 fine, 60 hours community service, GWI first standard conditions in the installation of an interlock device. In addition to that, the case, the companion UCW case will be dismissed for forfeiture.
This is the court, is this the court call? You gotta know this.
Who is it on, Judge?
That's on McCracken.
Oh, 392?
Yes.
Okay.
Okay. Mr. McCracken, the state is offering that you serve 180 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you will be placed on probation for a period of 18 months. During the 18-month probationary period, you'll be required to pay a fine of $1,000 plus a DPS fine of $100. You will also be required to pay court costs of $392, a probation fee of $60 a month, a urinalysis fee of $15 a month, reimbursement fee of $15. You will also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $168 a month. Will you be able to pay the $168 a month?
Yes.
You will also be required to perform 60 hours of community service, install an interlock device on any vehicle that you own and operate, attend and complete a DW education class, have a drug and alcohol assessment, adhere to the other standard terms and conditions of your probation, and the state will be dismissing cause number 23CCCR 0649 for forfeiture of the weapon in that case. And I have before me document that is titled Motion to Forfeit the weapon to the Texas Department of Public Safety. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
It is.
Now, Mr. McCracken, before you sign this document, did your attorney go over this document with you?
He did.
And did you read and understand everything that your attorney went over?
Yeah.
And is everything in this document true and correct to the best of your knowledge?
It is.
And are you requesting the court to grant your motion to dismiss, or not to dismiss, but to forfeit the weapon in cause number 23CCCR 06492, the Texas Department of Public Safety? Okay, the court is signing this motion, granting the motion to forfeit the weapon in this case to the Texas Department of Public Safety. And now, Mr. McCracken, do you understand the state's offer?
Yeah.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Mr. McCracken, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. McCracken, this will conclude your case. And before you go over there, I must let you know that the state I will also be signing the dismissal on cause number 23CCCR 0694. You can stand next to the bailiff and follow her directions. Once you finish following her directions, you're free to go and you have a blessing. Yeah, hold on a minute. I did. Unless you have to send it back. I thought I just signed. It didn't come back. Let's try it again. Nope, it didn't come back. Yes, I have his dismissal. Mr. Hall, I have his dismissal.
Let me have that paperwork back.
I'm in the other document. You sent me a dismissal.
That's what you gotta sign.
I just signed the dismissal. I hadn't signed the dismissal when you had said I didn't sign. I was signing in the process of signing it. You have it now? It's signed? Okay. Okay, Ms. Madali?
It's on Eric Corbin. We just got word from drug court. They're resetting it for a week to decide what to do in terms of this felony. So
Okay,
if you would like to reset it 1 week, I'm amenable to that. I'm also amenable to doing a normal reset so that they have time to work a plea deal out.
well, what we'll do is we'll set it on the same day
Okay.
that the felony case is set.
It's
And
not
so
in there. It's not that
the
you-
court
Okay.
coordinated that. All right,
Thank you.
all right, we'll see you later. You have a blessed day. Okay, have they talked?
Yeah, he doesn't want to accept.
Okay,
He said he wants them there. But-
okay, Mr. You have to change his paperwork. You want to hire, is that correct?
We
Okay,
don't need this.
you have
He
to
needs to say-
change the paperwork.
Yeah.
Let me, where is his? Oh, is it right here?
Yeah, I need to get another side, but you don't have to.
Okay, now, Mr. Now, here you go. He has to change his.
Yes.
He has to strike through where it says he wants to represent himself to, he wants to hire. Okay,
You know, there's another issue as well.
okay. We'll do,
Yes, sir.
we'll deal with that in a minute. Adams, Langston has a case. Okay, now, Mr. Coleman, have before me, oh, so you already hired an attorney already?
Oh.
Because you put Giles Cole on here. Is that's what it says?
The second line is intent to hire.
Hmm?
The second line is for intent to hire.
No, it says I have hired, which means you've already hired. So he said he wants his case reset to hire, right?
Yes, sir. I spoke with him on it. I just didn't know that.
Is that correct?
Yeah.
Okay, so now your case is gonna be reset. So give you an opportunity to hire your attorney. Mr. Gilliam, you had another matter?
Yes, sir. He's refused to take a drug test.
Okay, now what the court is going to do, the court, you out on bond? You have to be out on bond for you to be present in court.
But for them to appeal, yes, sir.
Yes, okay. Now the court is going to, you refuse the drug test, the court is gonna find that your bond is insufficient. Which means that you're gonna be taken into custody. And you just follow the bailiff. Okay, who we have next? Jermaine Dancy, please come forward. Mr. Dancy, we call your name like you was just waking up.
I'm a little bit tired.
You a little tired? Okay, just letting you know the court is not a place for you to go to sleep in a lounge.
You know, my bad.
Okay. Now, your attorney is Attorney Langston Adams. He's appearing on Zoom. Mr.
Here,
Adams,
Judge.
how are you doing?
Doing well.
Okay, now, Mr. Adams, what is your announcement in Mr. Dancy's case?
Judge, if you can give me one last announcement to get discovery and go through with him, I'll be ready to rock and roll when we in court next.
Okay, I see this is a relatively new case. All right,
Yes, sir.
now, okay, give us a reset on announcement.
August 14th.
Okay, this case will be reset August 14th, 2024 for announcement. Mr. Dancy, you're gonna get your reset here in court. Once you get your reset, you'll be free to go and you have a blessed day.
Yes, ma'am.
And Mr. Adams, your reset will be sent to you. You're free to go. I think this is your last case, and so you have a blessed day as well.
Thank you, Judge. I appreciate you.
Okay, now, Mr. Dancy, have a seat in that first chair by the wall. Because we didn't see his name on the docket as your attorney. What normally happens is when an attorney gets hired on a case, they are required to send a letter, a representation. They file a letter of representation in the county clerk's office, informing the court that they have been hired to represent the defendant. He didn't do that. So it's-
Person on the docket today.
who is that? Baker? Baker's a no-show, yeah, she has a warrant. Okay, the court is being recessed. Mr. Reynolds?
Yes, sir.
Moulton? Hold on. Reynolds. What is this? Yeah, this is clause number 24 CCCR 0170. Ms. Reynolds, Ms. Moulton, are you all right?
Yes, yes.
Okay, like you was kind of struggling trying to
She's,
find your way.
she said 3 strokes, Your Honor.
Oh, okay. Okay.
Sorry.
No, that's not a problem. Do you need to sit down?
No.
Okay, because we can allow you to sit down. Now, Ms. Moulton, you represented by the attorney Nathan Reynolds?
Yeah.
Attorney, how are you doing?
Doing well, Judge. Thank
And Ms. Moulton, how are you doing? Not that good?
But how are you?
I'm doing fine, and thanks for asking.
Thank you.
Now, Mr. Reynolds, what's your announcement in Ms. Moulton's case?
Judge, this is our first announcement. She has no prior criminal history to this case. I'd like to see about possibly getting her into the pretrial program.
Okay, pretrial
Could
diversion.
reset that to the next.
When is the next pretrial diversion sign up? I think it's June, July.
I think
Is it August?
I believe it's August, Judge.
Okay, so we're gonna reset the second week in August. Give us a reset date.
August 12th.
Okay, we'll reset it for August 12th. Ms. Moulton, your attorney gonna get your reset. Once you get your reset from your attorney, you will be free to go. You have a blessed day.
Oh.
And we pray that you have a full and speedy recovery from your
Thank you.
your illness. All right,
Appreciate it.
All right, you're welcome. You can just go have a seat. He'll get to, just have a seat. He'll get it to you. Once you, if you need some assistance.
I scared her, shit, I thought.
This is cause number 23CCCR 1322. Cases, I don't see it in there, okay. Case is styled the state of Texas versus Jeremy Mars, or Jeremy Jamal Mars. Ms. Mars, is that your full name?
Yes, sir.
How are you doing, Ms. Mars?
All right.
I'm doing all right. Mr. Morris, on the docket sheet, it doesn't show you that you have an attorney record. However, we have Mr. Marvin Lewis, who has informed the court that on yesterday,
Yes, sir.
you hired him as your attorney. Is that correct?
Yes, sir.
Now, we haven't received the letter of representation. It may still be in the clerk's office. They hadn't put it in the system that's a possibility. And so this case is going to be reset. Let's see. This case is going to be reset because Mr. Lewis has to get discovery. That is, he has to get the evidence
Yes, sir.
from the district attorney's office so that he can prepare to represent you.
Yes, sir.
All right? And so give us a reset date. We'll keep it on the announcement docket.
Yes, sir.
Okay. State, do you have any objections?
No, thank you, Your Honor.
Okay. So this case is going to be reset August 14th for announcement.
Yes, sir.
Your attorneys, you're going to get your reset. Once you get your reset, you're free to go.
Yes, sir.
And you have a blessed day. And Mr. Lewis, you're free to go as well. And you have a blessed day.
Thank you.
All right. Who else do we have?
And I have one more, Judge.
Oh, you do?
Siobhan Sylvester.
I saw Sylvester. Yeah, Siobhan Denise Sylvester. She may
Yeah.
make a. Okay, this is cause number 24CCCR 0788. Case is style of state of Texas versus Siobhan Denise Sylvester. Ms. Sylvester, is that your full name?
Yes.
How you doing, Ms. Sylvester? That's good. You can't be better than being blessed. I see you hesitated for a while and then you started counting your blessings.
Yes.
All right. Now, Miss Sylvester, you representing your case by your attorney, Marvin Lewis. Mr. Lewis, what is your announcement, Ms. Sylvester case? This is a real new case.
Yes, Judge. I have received discovery on this, our first setting with this case, Judge.
Okay.
As well as an offer, but I do need some time to talk with Mr. Wester on that.
Okay.
We'll see if we can get this resolved by the next setting. If we could possibly have that August 14th date and keep it.
August 14th, keep it on announcement docket.
On announcement docket, that'll be.
Okay, we'll put it on August 14th for announcement.
Okay.
Ms. Sylvester, your attorney's gonna get your reset. Once you get your reset from your attorney, you're free to go. And you have a blessed day. Continue to have a blessed day.
Yes, sir. Thank you.
And Mr. Lewis, you're gonna get your reset and you have a blessed day as well.
All right, thanks, Judge.
All right. Go ahead on the Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 23 CCCR 2308, case of style of state of Texas versus Crystal Baker. Crystal Baker was scheduled to be in court this morning at 9 a.m. for the court's announcement docket. At or about 9 a.m., the bailiff called Crystal Baker's name at the courthouse door. Crystal Baker did not answer. Crystal Baker has not appeared in court since the court has been in session. The time now is 11:34 a.m. on today's date of June 26th of 2024. Ms. Bailiff, would you please call the name of Crystal Baker at the courthouse door? Okay, Crystal Baker's name was just called again at the courthouse door. Crystal Baker did not answer. A reasonable time has passed to give Ms. Baker an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
So move for bond forfeiture.
That motion will be granted. Crystal Baker's bond will be forfeited and a warrant shall be issued for her arrest. In cause number 23 CCCR 2308, and the court will be in recess until Mr. Wright Kimberler arrive on, well, in cause number 23 CCCR 1258, Chelsea Nicole Petaway. Will be in recess. Okay, court is back in session in cause number M 331-316, case of South State of Texas versus Desmond Deshaun Coleman. Mr. Coleman, the court previously found that your bond was insufficient in amount pursuant to Article 17.09. The court is going to reset your bond, and the court is going to give you some bond conditions. Ms. Bailiff, would you please hand these bond conditions to Mr. Coleman? Okay, Mr. Coleman, the bailiff has just handed you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over these bond conditions with you. Any reasons following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Now, condition number 3 does not apply. Condition number 4 does not apply because 4 only applies in the DWI second case, which is a motion to revoke probation for possession of controlled substance penalty group 2A greater than or equal to 2 ounces. That is not a DWI second. Now, condition number 5 does apply. It says defendant will obtain and participate in the Spindletop ATAR. ATAR stands for Addiction Treatment and Recovery Program. And do you understand that condition? Now, condition number 6, the defendant will remain drug and alcohol free. Do you understand that condition? And condition number 7, participate in the ASAP program with Spindletop Center, and the address is 2750 South 8th Street, Beaumont, Texas. Building C, South 8th Street, Building C, Beaumont, Texas, 77701. Do you understand that? Now, if you violate any one of these conditions of your bond will be revoked, will be arrested and placed in the Jefferson County Jail. The court has to review some information on in setting your bond. Now, the court is going to ask you some information that is not public, and I'm going to I need that information to set your bond. Okay. And so this portion of the hearing pursuant to Article 1.246 Code of Criminal Procedure will be closed to the general public. And the court is going to this hearing to the general public. The bond conditions, not conditions of probation. It's like there are two different things. Okay, while you're out on bond, you're gonna have bond conditions. Okay, now let me do this. Well, right now, we don't have a letter rep from your office.
I know.
No,
That's what she just said.
No, sir.
You haven't heard me on this? I think I remember talking to you. I thought you did. All right, I'll get one in.
Well, I didn't get one done.
So they'll just send it to, just put it on a trial docket.
Okay.
Just set it on a trial docket. You gotta get the letter rep in. Case is gonna be reset. Once your case is reset, you're free to go.
Check.
Thanks for being patient with us, and you have a blessed day. Mr. Kimler, you have a blessed day as well. And this will conclude the calling of the court's announcement docket and motion to revoke the vacant docket. Both dockets scheduled on the day's date, June 26, 2024, in County Court at Law Number 2. Mr. Hubel and Ms. Simmons, you're free to go. You have a blessed day, and Mr. Kimler, you're free to go as well, and you have a blessed day. And this will conclude the following of the court's dockets on today's date, June 26, 2024, in County Court at Law Number 2, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. You're welcome.
But not for